To understand corporate law, we have to isolate the exact moment an abstract business idea crosses a boundary and becomes a recognized legal person. That transition happens at a specific point, the date the registrar issues the Certificate of Incorporation under Section 7(2) of the Companies Act. On this timeline, the left side represents the state before that date. Here, the company is a complete non-entity. The right side is the moment after. The entity now possesses immediate legal capacity, capable of holding property and entering contracts. Courts enforce a strict double standard across this line. They refuse to recognize commercial deals made prior to the certificate's issuance. Yet, once the line is crossed, they refuse to unmake the company, even if the documents used to create it were entirely fabricated. To navigate this system, you must accept that the date printed on the certificate overrides physical reality. It is an absolute legal fiction. This node-based assembly line illustrates Section 3. 7 members form a public company, 2 for a private company. A one-person company requires a single member, nominating a consenting heir. These flow to the registrar under Section 7, alongside the memorandum, articles, and affidavits. The affidavit is a formal guardrail. Every subscriber must swear they have not been convicted of fraud in the preceding 5 years, and that documents are complete. If the registrar discovers a lie, the state invokes Section 447, triggering severe punishment for fraud against promoters. Post-incorporation, a judicial tribunal gains broad powers to penalize the deception. They can strip limited liability, forcefully regulate the management, or order total business winding up. Notice the mechanism of punishment. The tribunal must formally wind the company up. This raises a difficult question. If the inputs were fraudulent, does the company itself still exist during the trial? To see why the law separates the creator's fraud from the creation's existence, we have to look at the precedent set by the Privy Council. Logic suggests that if a contract or registration is based on illegal inputs, the resulting entity must be void from the start. That assumption was tested by the Judicial Committee of the Privy Council in the case of Musa Ghulam Arif, the Ibrahim Ghulam Arif. The foundation was obviously defective. Only 2 of 7 signatures on the memorandum belonged to adults. The other 5 were minors. This failed statutory minimums, but the registrar missed the defect and granted the Certificate of Incorporation anyway. The plaintiff attacked the certificate directly. They argued that because foundational conditions of registration were unmet, the entire incorporation process should be declared void. The Privy Council rejected the argument. They established that once the certificate is issued, the output, the resulting company, is decoupled from the legality of its inputs. The Privy Council drew this rule from a precedent established by Lord Cairns in Peel's case. In a scenario where a memorandum was altered without authority prior to registration, Lord Cairns held that the Certificate of Incorporation is a conclusive answer. It prevents all recurrence to prior matters and stops any inquiry into the regularity of the proceedings. This is the conclusive evidence doctrine. The validity of the certificate cannot be disputed on any grounds whatsoever. Indian courts apply this doctrine rigidly. In T.V. Krishna v. Andhra Prabha, a company was formed for the allegedly illegal purpose of evading financial responsibilities imposed by a government wage board. The court held that even if the objects were illegal, the registration was valid. The certificate acts as an iron shield. Once the corporate persona is born, it cannot be assassinated by attacking its birth. It must go through the formal statutory execution process of a winding-up order. Let's shift the timeline to the left, stepping back into the dark void that exists before the official Certificate of Incorporation is finally issued. The common law rule of contracts requires 2 consenting entities. Because the company does not legally exist yet, it is a non-entity, incapable of contracting. It cannot even agree to a deal retroactively. As seen in Natal Land and Colonization Co., a company cannot obtain the benefit of a pre-incorporation contract by ratifying it after it is born. Watch the mechanics of this in our node diagram. A third party attempts to bind an agreement to the proposed company, but the target is a phantom. The legal connection fails to attach and drops. This creates severe consequences for founders, as in Kellner v. Baxter. Promoters purchased wine for an unformed company. Because the principal did not exist, the liability line whips backward, locking on to the promoters personally, forcing them to pay. The Bombay High Court reinforced this in Ramkumar Poddar. Even if a managing agent's appointment is written into the preliminary memorandum, the unborn company cannot be bound by it. The judiciary inflicts personal liability on founders to ensure the newborn corporation is not saddled with the heavy obligations of overly optimistic promoters. There is a statutory patch to bypass this common law trap, found in Sections 15 and 19 of the Specific Relief Act, 1963. For a company to safely adopt a pre-incorporation contract, the contract must be for the purposes of the company, and it must be warranted by the Objects Clause in its terms of incorporation. The Supreme Court requires the company to affirmatively accept the transaction post-incorporation. The transfer of liability is not automatic. If these conditions fail, for instance, if the contract is an agreement to allot shares later, the statutory patch collapses and the company cannot enforce the contract against the other party. Without meticulously executing the requirements of the Specific Relief Act, the pre-incorporation void remains fatal to commercial agreements. Let's bring the entire model together on this timeline. On the left, prior to the certificate, the company is a phantom. Promoters absorb all personal liability. But the exact moment the certificate is issued under Section 7.2, the corporate veil drops into place. The personal liability of the founders is severed. Even if that certificate was obtained through deception or legally deficient documents, the resulting corporate entity is legally real. The state's only recourse is to use the Section 447 fraud hammer against the founders personally, or petition a tribunal for a formal winding up. The certificate of incorporation is the point where law overrides physical history. It is a piece of paper that creates a new legal reality so powerful, even its creators cannot retroactively destroy it.